Okay, we are online now.
Good afternoon, ladies and gentlemen. Thank you all for joining this afternoon for our joint webinar organized by the Ukrainian Arbitration Association and the Swiss Arbitration Center. My name is Tatiana Bersheda. I will be the moderator of this webinar. And before introducing myself, let me introduce you our panelists. Probably you know most of them. Sergei Uvarov is the president of the Ukrainian Arbitration Association and a partner in Integrates, a leading Ukrainian law firm. Sergei works predominantly with international commercial and investment arbitration. He also serves as expert on Ukrainian law before foreign courts and arbitral tribunals. Alexei Maslov is a board member and the Secretary General of the Ukrainian Arbitration Association. He's a partner at another leading Ukrainian law firm, Abelum, specializing in international arbitration and cross-border litigation. Alexei regularly speaks and writes on arbitration-related topics, and he serves at the ICC Commission on Arbitration and ADR in 2024-2027. From the Swiss side, we have Professor Felix Dasser, who is a partner in the Swiss law firm Homburger. He has more than 30 years of experience with a focus on international litigation and arbitration. He is the current president of the Swiss Arbitration Association and has been the president since 2020. Felix is also a professor of law at the University of Zurich and has been teaching international civil procedure and arbitration not only in Zurich, but also at the Hague Academy of International Law, as well as at the China University of Political Science and Law. Felix Dasser also acts as arbitrator and is expert on Swiss law in foreign court and arbitration proceedings. His biography goes much longer, but because of the limited time, I'll have to pause here. Stephanie Pfisterer is also a partner at Homburger. She specializes in international arbitration as well as litigation. She regularly acts as counsel and arbitrator in arbitration proceedings. She is the vice president of the Court of Arbitration of the Swiss Arbitration Center and a member of the ICC Commission on Arbitration and ADR. She's a member of the task force, which drafted the TEF rules. As some of you might already know, it stands for Trust, Estate and Foundation Rules, which we will be discussing today among the new developments in the Swiss arbitration law. Stephanie also serves as Homburger's co-head of diversity and inclusion and ESG and teaches at the University of St. Gallen. Myself, I'm a dual qualified lawyer, qualified in Switzerland and in England and Wales, with over 15 years of experience in international arbitration and cross-border dispute resolution. Originally, I'm from Ukraine and very proud to be. I'm the founding partner of Bersheda Law, a boutique practice focused on complex commercial disputes, private client matters, and international enforcement strategies. In the field of international commercial arbitration, I regularly appear as counsel and as arbitrator across a broad range of institutional and ad hoc proceedings. So here we are, and we'll start with a general presentation of Swiss arbitration law by Professor Dasser, and I give the floor to him.
Okay, thank you very much for this kind introduction. Let me share the screen. So, good afternoon, everybody. It is a great pleasure to participate in this webinar. You probably know already from earlier webinars, we really sympathize with your fight to remain free and independent, and we are ready and willing to assist you in any way whatsoever, you, the Ukrainian lawyers, in these unfortunately very challenging times. So we is Swiss Arbitration Association ASA, and that is my next slide, which I tried. Here we go. We are basically a global association with 1,000 members from all over the world, basically. founded already in 1974. That was a time when basically a handful of lawyers from Switzerland, from France, and a few others basically defined arbitration as we know it today. And by now, we are working together with associations all over the world, including, to our pleasure, with the Ukrainian Arbitration Association. That is ASA, basically took control of the Swiss Arbitration Center. At the time it was called SKY, now the Swiss Arbitration Center, so that everything is basically under one roof. And this is really the roof, swissarbitration.org. You find everything about ADR, arbitration mediation in Switzerland, on this internet portal. Just, some bragging, apologies for that. When you look at the ICC arbitration proceedings, Switzerland has always been one of the favorite venues for arbitration. Of course, when you look way, way back, it was together with France. It was number one and number two in terms of venues. In the meantime, of course, arbitration become popular and also from a legal perspective, feasible, in many other jurisdictions. But Switzerland is still extremely popular in ICC proceedings, which means that we have a lot of experience, and we are more than happy to share those experiences with others like you. The background why Swiss law or Switzerland is so popular as a venue is to a large extent due to our arbitration law. Back in the 1980s, we basically devised all at the time the most liberal arbitration law, even more liberal than the French arbitration law. You see it's a very short act, 23 articles. It's all about party autonomy, and there are some characterizations that are also unique, like for example that the arbitrability is very, very broad, and that is of relevance also for today's webinar. We will come back to that. The arbitration agreement is valid, and that is also something unique. If it is valid under Swiss law or also under the law applicable to the substance of the dispute. So there is no discussion about whether the lex causa or the lex arbitri should be prevalent. It doesn't matter. If there is one law that says this arbitration agreement is valid, then that's fine for us. So that's pretty unique. And then we have also something that is unique and or less unique now, but important for what we will hear about later. That is arbitration clauses in unilateral legal documents, trusts, bylaws, foundation documents, and all of that. And then, and I will come to that in the next slide, the minimal review. Now, all of this is possible because of that pretty unique habitat of an arbitration community in Switzerland, with a long tradition harking back more than 100 years of international arbitration, with arbitrators who have a lot of experience also from abroad, trained abroad. And that means that in Switzerland, the government, the legislature, but also the court, put a lot of trust in the quality of the arbitrators. Whether that trust is deserved, that's not a question. And I would not vouch for every single person in Switzerland or abroad that happens to be an arbitrator in Switzerland. But all in all, it's a community that holds up to the promises and the expectations. And that in turn leads the legislator to keep a back seat. And that's very important for a venue. When you have a successful arbitration venue, the legislator and the courts need to grant a lot of leeway to the parties and to the arbitrators. And that is really what happened in Switzerland. When you look at the next slide with the 1, the 6, and the 7, that is when you challenge an award, you go directly to the Federal Supreme Court. And so we have only one instance. And that sole instance only takes about 6 months to finally deal with any challenge. And basically the Federal Supreme Court says, well, you chose arbitration, you got arbitration, so don't complain. That's why the chance of success is very small. That's also, of course, a reflection of the generally very good quality of arbitration proceedings in Switzerland, of the Swiss Arbitration Center, and also of the arbitrators. So, and that is for me an important message. In many jurisdictions, you can spend 1-2 years in arbitration, but then the challenge proceedings can take years. There's so many examples where you spend more time in the courts in challenge proceedings than in the arbitration. Then I don't think that's really the idea of arbitration. Now, apart from that, Swiss arbitration offers a few tools for everybody. So tools that you can use in Ukraine, even if there is no nexus whatsoever with Switzerland. And one of them is the ASA profiles. When you're looking for an arbitrator, we have a database which is free to use with a lot of filters that help you search the right person. And we have more than 1,000 profiles of people who are ready to act as arbitrators or mediators, also experts. So that is really a database, a treasure trove of persons that you could also rely on and use for proceedings in Ukraine or elsewhere. Or the Swiss Arbitration Hub. This is a platform for when you have a hearing in Switzerland. That can also be under proceedings that are seated elsewhere. But for some reason you want to have one hearing, a witness hearing or whatever in Switzerland, here you can organize it, find a facility, interpreters and so forth. So that's very convenient for that. And very useful, and I use that very often, also abroad in, for example, at law schools, but also for practitioners. I myself use it when I need, for example, a template for a specific procedural order. The arbitration toolbox is not limited to any Swiss law or Swiss rules. It can be used to any proceedings, arbitration proceedings, under any rules whatsoever. That is why the toolbox is uniquely recommended by UNCITRAL. You find a link to the toolbox also on the UNCITRAL website. And finally, there is the Global Tribunal Secretary platform, the most recent addendum to our buffet of tools. When an arbitrator is looking for a tribunal secretary to assist in the proceedings and doesn't have one available, you can look for a potential tribunal secretary on this platform. You can filter, what is applicable law, what language is, where should he or she be available. So that is also something unique, and a huge success has become on a very short time period, very popular on a global level. It has been developed together with our specialist arbitrators from all over the world, basically. Okay, so that is just a few tools that can be used also independent of Swiss law. The Swiss rules of international arbitration, you will hear more in connection with the specific topics that we will address today, but here just a few general words. First of all, it shouldn't have too many surprises because they're mostly based on the UNCITRAL arbitration rules. Of course, UNCITRAL arbitration rules are ad hoc, and these here are institutional rules, so there is a light administration put on top of the UNCITRAL arbitration rules, but rather light administration, but light and efficient. The arbitration court, of which Stephanie Pister is the vice president, is a body with very experienced practitioners from various jurisdictions that are hands-on. They can act and react to requests or issues that arise on very short notice with a lot of experience. So that is something that we are very proud of in Switzerland, to have such an arbitration court supervising the proceedings, assisting the parties if some hiccup arises. And of course, they have some progressive features that but that these are features that you will find also elsewhere. Interesting, you can get ex parte interim measures. So if there's really an issue, timing issue, the Swiss arbitration rules also help. And you will hear more about the supplementary rules for corporate disputes and trusts foundation disputes. So much about the Swiss Center. We are very proud of it. The Swiss Arbitration Association is majority owner of the Swiss Arbitration Center, but we have all the relevant Swiss chambers of commerce as co-owners. So we are working together. The chambers of commerce, of course, can recommend that center to their thousands of members, and are very important to also help us to be close to the needs of the users. And maybe final point, very often Swiss law, contract law, is chosen together with Swiss arbitration, and for a good reason, because first of all, I mean, it's a civil law, so familiar to most of the lawyers in other civil law countries, and easy to apply. I always have to to laugh when English lawyers say that the English law is very easy to apply. That's not my experience. When I ask an English solicitor what is the law on this or that, they often turn around and ask a barrister, because they themselves have no clue. Sorry, I'm a bit sarcastic now, but for me, it's important that you can actually look up the law in a book, and you can do that. You can also look up the code. It's in a straightforward language. There's an English translation, so it's actually very accessible. And first of all, and most importantly, there's maximum freedom of contract. So for international contracts, it is really time tested. It works. It has in thousands of cases, it turned out to work. And one of the reasons why it is so popular is also because of the principle of good faith. It's not like the principle of good faith replaces what the parties agreed, but it helps figuring out what the parties actually have agreed. And they have agreed on what they, people in good faith, have agreed. So no sharp dealing under Swiss law. So much. That is why in ICC arbitration cases, Swiss law is the most popular civil law, basically every year. No, not basically every year, every year. Even in cases where there is no seat. So that is just another comment for that might be helpful. And with that, I think I stop here and pass the floor back to Tetiana. Thank you.
Thank you very much, Felix, for this very comprehensive overview of the Swiss arbitration law. And I think we are all now convinced that the choice of Swiss substantive law and of the Swiss Arbitration Center is very appealing. One of the reasons for which it's so appealing is because of the very large definition of arbitrability, which encompasses all matters which have a financial patrimonial value under Swiss law. And therefore, it was quite easy for the Swiss legislature to extend the arbitrability to corporate disputes and to private wealth disputes, as we will discuss a bit later and more in detail in this webinar. But before going into the specific areas of law, maybe Sergei could tell us a few words about arbitrability under Ukrainian law, with a specific reference to the arbitrability of corporate disputes, which will be the next topic we will be discussing, and I will be presenting under the Swiss law.
Yes, thanks, Tatiana. First of all, from the Ukrainian Arbitration Association, I would like to say a huge thanks to the Swiss Arbitration Association. Indeed, we have been partners for quite some time already, and so we really appreciate all the help and support from the Swiss Arbitration Association to Ukraine. And happy to have this webinar as well, because quite peculiarly, probably, Ukrainian law on arbitration, although still it can be called quite developed, but it is not flexible at all, unlike Swiss law on arbitration. In particular relates to the notions of arbitrability. And in Ukraine, I would say that the regulation of arbitrability is quite fragmented because we do not have one uniform rule on arbitrability. Rather, it is the regulation can be found in three main sources. The first one is the law on international commercial arbitration. The second one is the law on private international law, and the third is the Commercial Procedure Code of Ukraine, like procedural code. And the problem with all these regulations is that none of them is comprehensive. So, for example, in the law on international commercial arbitration, we have Article 1, which sets out what seems to be like a general rule on arbitrability, because it describes the disputes that can be referred to arbitration. And in particular, such disputes include those that arise from contractual and other civil legal relations, and that arise in the course of foreign trade and other types of economic relations. So basically, from the perspective of subject matter arbitrability, there are two cumulative criteria. First, civil legal relations, and the second one is for foreign trade or other types of economic relations. And I think already here it is obvious that the scope of arbitrability under Ukrainian law is quite more narrow than in Switzerland. But there is also another problem with this law is that this law applies only to arbitration seated in Ukraine. So basically, this general rule on arbitrability does not apply at all to arbitration seated abroad. So, for example, when the Ukrainian court deals with recognition and enforcement of a foreign arbitral award, it basically cannot apply this rule to determine whether the matter was arbitrable or not. So the second source of regulation on arbitrability is the law on private international law, and it does not contain any general rule on arbitrability, but rather it contains an article, a provision dealing with the exclusive jurisdiction of Ukrainian courts in international matters. And to be fair, there is a quite significant dispute and disagreement between practitioners whether this provision at all governs arbitrability, because many think that it does not. It just regulates the division of jurisdiction between Ukrainian state courts and foreign state courts. But the court practice in Ukraine apparently goes the other way. And finally, the third source of regulation and arbitrability is the Commercial Procedure Code. Arguably, this is the most comprehensive regulation. And again, it does not have a general rule, a guidance as to what matters should be arbitrable, like you said in the under Swiss law. This is something that have a financial value, or I know that, for example, in Sweden law, the other criteria applies, like every matter on which the parties can enter into settlement agreement. So no such general criteria is available here, and rather the Commercial Procedure Code that says that all matters that are subject to the jurisdiction of the commercial courts in Ukraine can be referred to arbitration, except for the list of exceptions. And there are two problems with this regulation in the Commercial Procedure Code. First is the first problem is the Commercial Procedure Code itself, because the question will often arise: what should we do with the disputes that are not subject to the jurisdiction of the commercial court, but, for example, subject to the jurisdiction of general civil courts? So can those matters at all be referred to arbitration? Well, apparently they should be capable of being referred to arbitration, but then the question arises whether there are any restrictions on arbitrability, because strictly speaking, the restrictions in the commercial procedure code would not apply to them. So there is a lot of uncertainty there. And the second problem is, again, the lack of this general rule, which would serve as a guidance for interpretation of the exceptions, because the exceptions to arbitrability sometimes formulated quite vaguely or unclearly, and this creates difficulties for interpretation. The courts may be tempted to interpret those exceptions quite broadly, and they may be tempted to rule that certain matters are not arbitrable, where, well, basically in most of the developed jurisdictions, these matters can be resolved in arbitration. I will stop here, not to overwhelm.
Thank you very much, Sergey. It's very interesting and actually very complex as it appears for us in Switzerland. So now we have to move to more specific topics about the new or more recent developments in Swiss arbitration law. And we would like to introduce you to two sets of supplemental Swiss rules, which were issued by the Swiss Arbitration Center. The first one being supplemental Swiss rules for corporate law disputes, which I will present now. So I'll start sharing my screen. Does it work? Can you see my slides?
Yes.
So the new development in the Swiss arbitration law and in Swiss company law as well is that the Swiss legislature decided to embed in the Swiss statutes the recognition of the arbitration clauses in the corporate statutes or in the articles of association of the companies. So we have new provisions. One is Article 178, paragraph 4 of the Private International Law Act. Just as a reminder, when we deal with arbitration seated in Switzerland, the arbitration will be governed either by the PILA or Private International Law Act, if it has an element of extremity or it's an international case, or it will be governed by the Swiss Code of Civil Procedures, or I abbreviated as CCP on the slides, for domestic arbitration. So if there is no foreign element in the case, we'll apply the CCCP, and otherwise we will apply the provisions of PILA. But in this instance, on the substance, there is no difference because the rule is exactly the same. So we do recognize arbitration clauses in the articles of arbitration, both in international and in domestic arbitrations seated in Switzerland. So we have to deal with an arbitral tribunal with a seat in Switzerland. This, in addition to the Private International Law Act, the Swiss legislator also introduced a new provision in the Code of Obligations, where we have a special chapter devoted to the company law. And as of the 1st of January 2023, there is a new Article 797N, which provides that, the articles of Swiss stock corporations may provide that disputes under company law are to be adjudicated by an arbitral tribunal seated in Switzerland. And based on this provision, the Swiss Arbitration Center issued supplemental Swiss rules for corporate law disputes, which we will discuss more in detail later today. These rules can be declared applicable in the arbitration clause itself, even though it's not mandatory. It is highly recommended because not only the Swiss Arbitration Center created model clauses for the articles of association, but it also created specific rules which will make arbitration of corporate law disputes easier from the procedural point of view, and will deal from the outset with specific issues which necessarily will arise in corporate disputes, such as multitude of parties involved, for instance. So what is the scope of application of the new rules? We have to be in presence of a Swiss company, which means a company registered in Switzerland. It can be a private company or a public company. So as you will see at the end of this presentation, I have found one example of a publicly listed company which has introduced an arbitration clause in its articles. It's a Swiss perfume company, which is very well known. It's named Firmenich, and we will look at the clause itself a bit later. In addition to stock companies, limited liability companies could also introduce arbitration clauses in their articles, as well as limited partnerships. However, cooperatives and associations cannot have arbitration clauses in their articles. The clause must be included either at the time of incorporation, or it can also be subsequently added by a resolution of the general meeting with a qualified majority, which is a special rule with a combination of 2/3 majority and absolute majority of nominal value of shares provided for by the Code of Obligations in Switzerland. The clause must contain at least the necessary elements of an arbitration clause, which means it has to describe the disputes which are withdrawn from the jurisdiction of the state courts and which have to be submitted to arbitration. So it's important to avoid vague clauses and, as in any other field, pay specific attention to the wording used in the statutory arbitration clauses. The commercial registry order, so it's a special order which governs how the registry of companies in Switzerland is being held, was also revised, and there is a new Article 45, paragraph 1, letter U, which provides for the company's entry in the commercial register to indicate whether the articles of arbitration contain an arbitration clause. And based on the search of the register, as of today, we can say that more than 650 Swiss companies have introduced arbitration clauses in their articles of association. So they have been very widely used. However, so far, the Swiss Arbitration Center at least has not received any requests for arbitration. So to the best of our knowledge, there are no proceedings pending, but of course we might not be aware if there are any ad hoc proceedings. But this is the statistics of the Swiss Arbitration Center. And as I mentioned before, there is a model clause with the necessary elements and possible additional content which the Swiss Arbitration Center has developed, and we will look at it closer in the next slides. So what is the recommended content of the arbitration clause in the Articles of Association? The clause could stipulate that any corporate law dispute, excluding matters subject to summary proceedings pursuant to Article 250, letter C of the Code of Civil Procedure. So this provision lists a number of disputes specific to corporate law, which are subject to summary proceedings. And it's a special expedited procedure which exists under Swiss procedural law. And they are excluded from the scope of application of the arbitration clause. So other than those excluded matters, any other corporate law dispute shall be resolved by arbitration in accordance with the Swiss rules of international arbitration of the Swiss Arbitration Center, in force on the date on which the notice of arbitration is submitted in accordance with those rules. In general, a reference to the Swiss rules will automatically include the supplemental Swiss rules for corporate law disputes, unless provided otherwise. So you don't need to make reference to both sets of rules. Reference to the general Swiss rules will necessarily cover the supplemental rules as well. It is also necessary to indicate that the seat of arbitration is somewhere in Switzerland, and you can choose where, and that the arbitration should be conducted in a language of your choice. There are some possible additional content elements which are recommended. They are not necessary, but highly recommended, is to indicate how many arbitrators, 1 or 3, you wish to have, how the arbitrators should be appointed. The default clause provides for the appointment of arbitral tribunal by the arbitration court of the Swiss Arbitration Center. And this mode of appointment would resolve any issues which will arise from the multitude of parties. So you can imagine that if you have numerous shareholders as parties to a dispute, it would be in practice quite difficult to agree on a candidate to be arbitrator or co-arbitrator on the arbitral tribunal. Therefore, in such situations, appointment by a neutral, highly competent body like arbitration court of the Swiss Arbitration Center would be very useful. There is also an obligation to file, an obligation to file an action with the arbitral tribunal only and to raise an objection to the jurisdiction of state courts, which could be explicitly added to the clause itself. And there are some specific rules on costs, which are provided for as recommended but not mandatory content by the Swiss Arbitration Center, and on the delivery of notifications. It is important that all affected parties or parties whose interests are potentially affected by the arbitration proceedings be notified not only of the commencement of the proceedings, but of course of any award, whether partial or final, issued by the arbitral tribunal. And the supplemental rules provide for notification within 5 days of the beginning of the proceedings or of any decision of the arbitral tribunal. This notification should be delivered to all affected parties or eventually published in the Swiss official gazette or Swiss official newspaper where all official notifications are being published. There is also a provision on emergency relief, which refers to the emergency arbitrator proceedings under the Swiss rules. As to the scope of application of the statutory clauses, we should make a difference between objective scope and the subjective scope. So what is the subject matter of the arbitration clauses, the objective scope? Here it can be defined as all disputes arising out of or under the company law, which means that all disputes in which the alleged claims are based on a legal ground relating to the corporate relationship are arbitrable. On the screen, you can see some examples of arbitrable corporate disputes, such as claims for dissolution of companies, claims for annulment of decisions of the companies or general meeting of the companies, claims for liability of company directors, as well as claims for review following a restructuring of the company under the laws on the mergers in Switzerland. What is controversial is whether deficiency proceedings which are subject to the principle of officiality, or which means that these are not adverse proceedings, can be subject to arbitration or not. And the question has not been decided yet, so it remains open, and there are opinions which consider that anything which is non-adversarial in corporate law disputes should not be submitted to arbitration, but there are also legal opinions to the contrary. There are a number of fields which are excluded from arbitrability of the corporate law disputes. These are all the disputes relating to the contract law. So a dispute based on shareholder agreement will not be covered by the statutory arbitration clause. Therefore, when you have shareholder agreements in the context of companies, in addition to the statutory arbitration clause, it's highly recommended to coordinate the two clauses to make sure that their content is compatible and that proceedings can be consolidated to avoid contradictory judgments and all the other problems we usually face when we deal with parallel proceedings. There are some other restrictions which result from the model clause, as we've seen. So the disputes which are subject to summary proceedings are excluded. For instance, a claim of shareholder for disclosure or inspection within a company is subject to summary proceedings and will not be arbitrable. As to the provisional measures, if they are not expressly excluded, they are arbitrable. However, under Swiss law, the courts always keep parallel jurisdiction, and for reasons of enforcement, usually interim measures rendered by state courts are more efficient. As to the subjective scope of statutory arbitration clauses, the scope is determined by the Articles of Association, and unless provided otherwise, the clause is binding on the company itself, on the company's executive bodies, which means the board of directors, the auditors, the shareholder meeting, and the members of the executive bodies, so the directors themselves and the shareholders themselves. As to the timing, so if someone leaves the company, but the facts subject to the dispute relate to the period when the person was a shareholder and the arbitration clause existed already, the clause will continue to apply. And if someone joins the company after the clause was introduced, of course, these people will also be bound by the arbitration clause. De facto executive bodies, so de facto directors or people who are not formally directors but act as directors of the company, are also bound by the arbitration clause. So are also the auditors. However, the creditors for their direct claims are not subject to the statutory arbitration clauses. For instance, a direct claim in liability proceedings or initiation of proceedings for organizational deficiencies by creditors will remain subject to the state courts and not to the arbitration. Once we start arbitration proceedings under statutory clauses, we have to define the applicable procedural rules. So first of all, I would like to remind that we are always dealing with an arbitral tribunal seated in Switzerland, and therefore we will apply the Lex Arbitri, which will be Part 3 of the Code of Civil Procedure in Switzerland. There is opting out in favor of private international law under Article 353, paragraph 2 of the Code of Civil Procedure, which is excluded in the presence of statutory arbitration clauses. The Articles of Association can provide for applicable procedural rules either directly, so they can specify the rules themselves, or they can make a reference to arbitration rules, such as, for instance, the Swiss supplemental rules for corporate disputes. And there is one rule which the Swiss legislature considered to be particularly important in this context, and it is written directly in the law in paragraph 3 of the new Article 697N of the Code of Obligations, which provides that persons who may be directly affected by the legal effects of the arbitral award shall be granted certain rights of information and participation. And here I make reference to what I said earlier about delivery of notifications of the initiation of arbitral proceedings, as well as of decisions rendered by arbitral awards to affected parties. The Swiss supplemental rules contain 6 articles in total. Article 1 defines the scope of the rules. Articles 2 to 5 contain specific provisions on the rights of information, participation, and involvement of any third parties whose rights are affected. So these are the affected persons, and these are the necessary safeguards to protect their rights, as was expressed in Article 697N by the Swiss legislator, which considered this to be the most important requirement in corporate disputes and arbitration of corporate disputes. And there is Article 6 on urgent legal protection, and this provision makes reference to the interim measures and emergency relief, and provides that when faced with a request for interim measures pursuant to Article 29 of the Swiss rules, the arbitral tribunal may at its discretion refrain from deciding or defer its decision if it deems it more appropriate for a judicial authority before which a parallel request is pending to decide first, even if the request before the judicial authority was made later. It gives priority to state courts over arbitral tribunals to decide on the interim measures in case of parallel applications for interim measures in corporate law disputes. There is also a special provision for the cost of arbitration, because often those who prefer to go to court say that arbitration is more expensive. And for this reason, the arbitral tribunal may, at the request of a claimant who is a shareholder, impose the costs on the company regardless of the outcome of the proceedings, provided that based on the facts and the applicable law, the claimant had reasonable cause to file the action, and provided that the action doesn't conflict with the predominant interests of the company. So it's a deviation from the general rule we have in the Swiss rules, which more or less says that costs follow the event. So in general, the winning party will be reimbursed for its costs, and the losing party will have to cover the costs of arbitration. Here, even if the shareholder who files a claim loses, but if that shareholder had a reasonable cause, the arbitral tribunal may still decide to impose the costs on the company. And this is the price to pay for choosing arbitration in the Articles of Association by the company. The arbitral tribunal may also require the company to pay an advance for the costs of the proceedings and the legal costs of the claimant who is a shareholder. Maybe before the conclusion, I would like to show you here the only provision which I found among Swiss public companies, the only arbitration clause I found in the Articles of Association, and we can read it together. It stipulates that any disputes arising from or in connection with the corporate relationship in the company shall be exclusively resolved by the arbitration in accordance with the Swiss rules of international arbitration of the Swiss Arbitration Center. So it's an exclusive jurisdiction, and it makes reference to the Swiss rules and includes supplemental rules for corporate disputes. The number of arbitrators shall be 3. This meets the requirement of indicating the number of arbitrators, with claimant or group of claimants on the one hand and respondent or group of respondents on the other, each appointing 1 arbitrator, and the 2 arbitrators thus appointed designating the 3rd arbitrator, who shall be the chairperson of the arbitral tribunal. So here we deal with the multitude of parties, and the company chose not to use the default mechanism of appointment of the arbitral tribunal by the court of the Swiss Arbitration Center, and drafted the clause in a way which provides for a specific mechanism of appointment of the tribunal. The seat shall be at the registered office of the company, and the language of the proceedings is English. And then we have a specific statement saying this arbitration clause is binding on the company, on the governing bodies of the company, the members of the governing bodies, and the shareholders. Substantive Swiss law to the exclusion of Swiss international private law and any international treaties shall be applied to the merits of any dispute governed by this provision. So in conclusion, today we have more than 650 companies which introduced an arbitration clause in their articles, but so far no arbitration proceedings issued to the best knowledge of the Swiss Arbitration Center. We have good reasons to believe that confidentiality is a big concern for parties in corporate disputes and for the company itself, as well as for its shareholder, who is also concerned with the value of the company or value of his or her shares. And therefore, disputes which necessarily affect the value of the shares or of the company itself should be resolved in private, and arbitration is the most appropriate mode of dispute resolution when the concern of confidentiality is so important. And similarly to jurisdictional clauses in the articles, arbitration clauses protect Swiss companies from jurisdictions of foreign courts. So we already have case law in the US where Swiss companies which had jurisdictional clauses in favor of Swiss courts were not subject to the US courts. So the US courts declined their jurisdiction in the presence of such jurisdictional clauses. And we have all reasons to believe that in the same way, foreign courts will decline jurisdiction if there is an arbitration clause in the company's articles. Thank you for your attention, and I will give the floor now to Stephanie to introduce the other supplemental Swiss rules very recently, only this year, issued by the Swiss Arbitration Center for Private Wealth Disputes.
Thank you very much, Tatiana. So the TEF rules, as we call them, as you mentioned, these are a set of supplemental rules that have entered into force in June this year, and they govern an entirely different subject. They govern TEF disputes, and TEF stands for trust, estate, and foundation disputes. So I'll briefly tell you a little bit about the background of these rules, and then the rules themselves, the advantages of arbitration under the rules, and areas that still remain unresolved. So contrary to the supplemental corporate law rules, the TEF rules can apply to TEF disputes internationally, and the seat doesn't necessarily have to be in Switzerland. The seat can be everywhere in the world. That's one of the main differences. The background of the TEF rules is that Switzerland has become a key forum for complex private wealth disputes, in the sense that Switzerland has attracted a number of high net worth individuals, entrepreneurs, artists, but also heirs of fortune family, because of the tax-friendly system of some of the Swiss cantons. And because there are a number of high net worth individuals, they always come with disputes. That's why also Switzerland has seen quite a number of disputes, mainly about the division of estates. Now, these traditionally often go to litigation, but actually arbitration would offer a lot of advantages that would be beneficial for these disputes as well. For example, confidentiality, and the main advantage would be that you don't have a fight about the jurisdiction in these estate disputes. We often see that there are multiple jurisdictions, and we have multiple litigations ongoing in various countries, and arbitration would of course solve that problem, because it would all go to one forum. Now, the TEF rules, they of course must also be seen against the background of that 2020 reform of the Swiss arbitration law, both the international and the domestic one, which Tatiana has already mentioned, which now includes a provision on unilateral arbitration clauses. And in these TEF disputes, unilateral arbitration clauses, they also play a big role because a number of instruments in this area are unilateral. We're speaking about wills, we're speaking about statutes of foundations, which are also unilaterally drawn up by the founder of the foundation, and also trust deeds, which are unilaterally drawn up by the settler. So the supplemental Swiss rules for trust, estate, and foundation disputes have been created to address the challenges that exist in this area. They replace earlier rules that have been in place in Switzerland by an association dedicated to arbitration in the area of estate matters. Now, these rules, that association had been called SVSIE, very complicated name. These rules hadn't been very often used, and now the idea was to bring these rules in an amended version under the umbrella of the Swiss Arbitration Center, to benefit from the more global reach of the Swiss Arbitration Center. So what are the TEF rules? The TEF rules, as I mentioned, they are supplemental rules, pretty much like the corporate law rules. They supplement the Swiss rules, so they don't contain a full set of rules. They only supplement the Swiss rules. So it's basically still the Swiss rules that do apply, but there are some supplemental rules. These TEF rules, they apply to disputes out of wills, trust deeds, foundations, or if they are chosen by the parties. Now it's quite in details. It's a bit tricky when exactly they do apply. They apply automatically if the dispute arises out of a unilateral arbitration clause, and that is because in these cases where we have a unilateral arbitration clause, we have the most issues on actually who is bound by the arbitration clause, who should participate and who not. We have less issues if there's a bilateral arbitration clause, for example, in an estate inheritance agreement. So when we have an arbitration clause in a unilateral agreement, then the TEF rules apply automatically. If we have an arbitration clause in a bilateral agreement, then the parties need to specifically choose that the TEF rules should apply to their dispute. And what do the TEF rules contain? They contain pretty similar to actually the corporate law rules. They provide for articles specifically on the notification and representation of so-called entitled persons. I'll come back to that in a second. Then they contain special rules on tribunal appointment, and then they contain a conflict of law provision. So you can see the TEF rules, they actually only are only made up of 4 articles. So the first one about notification and representation of entitled person, that is because in estate matters, as well as in foundation and trust matters, it's quite often the case that the dispute does not only affect actually the party who sues and the defendant or respondent, but there are other heirs involved, other beneficiaries involved, and the like. And there we have to be very careful that all of these persons can actually participate in the proceedings, because otherwise the award may not be enforceable, because not all mandatory persons have been joined to the proceedings. And then we have special tribunal appointment procedures. Again, for these entitled persons, they need to have a say in the constitution of the tribunal. And then finally, we have a conflict of law provision for estate matters, for estate disputes. As you may know, the Swiss rules, they are similar to all other sets of arbitration rules. They provide that the parties can freely choose the applicable law. Now, in estate matters, this is not always the case, and very often there are mandatory statutory provisions, equally in Switzerland, that a testator cannot freely choose the law applicable to his estate. And the Swiss rules, they mirror actually these mandatory regulations, and they, to a certain extent, limit the freedom of the testator to choose the law applicable. You can find model clauses for various of these instruments, so trust deeds, foundation statutes, and the like in the TEF rules. So if you want to include an arbitration clause in one of these instruments, then please have a look at the model clauses that we have provided. Now, what do the TEF rules do? They provide for clarity and efficiency in cross-border cases. I've already mentioned that in estate disputes, as well as in foundation and trust disputes, you can have a variety of jurisdictions that apply. You can have the jurisdiction at the place of the where the testator died. You can have a jurisdiction where the assets of the estate are. You can have a jurisdiction elsewhere, and then quite often a number of courts feel competent to deal with the dispute. Whereas if you have an arbitration clause, you have one forum and that's it. The TEF rules, they offer also protection for all affected parties. I mentioned these entitled persons. They need to be notified. They have a right to have a say in the appointment of the tribunal. Flexible procedures and tribunal selections. I've already mentioned that in arbitration. You can, of course, freely select the tribunal with arbitrators who do have a knowledge in the special fields, whereas for state courts, you would often go to a general state court with your estate dispute. Strong enforceability of awards, because the TEF rules, they limit to a certain extent the law, the choice of law that the testator or that the settler can actually choose. And because they foresee that entitled persons need to be drawn in the proceedings and need to be notified thereof, they foster the enforceability of awards. Now, the TEF rules, unfortunately, they do not provide paradise. There are still a few areas that remain unresolved. Arbitrability is one of the issues. We've already heard a lot about arbitrability in Switzerland, and that is very broad. So in Switzerland, for international disputes, it's enough if you have an economic interest. And many of these TEF disputes, they do have an economic interest. So under Swiss arbitration law, estate disputes, they would be arbitrable. They would be arbitrable equally disputes about foundation matters. And I understand that this may well be different in other countries. And of course, here the TEF rules they cannot deal with these issues. So arbitrability is still an issue in some jurisdiction. Another issue that can't be fully resolved by the TEF rules is the binding effect of unilateral clauses for all beneficiaries. And this is also one of the issues that exist in Switzerland. In Switzerland, if we have unilateral arbitration clauses, we would normally construe them in a sense that beneficiaries of a will or trust deed, they are bound by that unilateral arbitration clause because they accept to be heirs, because they accept to be given part of the estate or part of the or that they are beneficiary of the foundation. Now in Switzerland we have a concept of so-called forced heirships. These heirs can't be excluded by attestators. So this concept that I've just explained doesn't work for these forced heirs because they have a statutory right to benefit from the estate. So there we can't actually say that they have accepted the estate, so they have accepted the arbitration clause. So this concept no longer works. That's why it's still unclear whether unilateral clauses are validly bind all beneficiaries. The third point deals exactly with that: forced heirship, forced statutory rights. That is where the arbitration is a bit an untested field. Then what we know from certain trust countries is that they very much protect the jurisdiction of local courts to deal with trust matters. Also there, the TEF rules, they of course can't guarantee that you can remove the jurisdiction from these local trust courts. And all of these issues, they of course lead to the fact that it's not entirely certain that you can enforce an award in TEF disputes, especially if you touch upon these issues of arbitrability, unilateral clauses, and then these trust jurisdiction. All in all, we would say that the TEF rules are a major step forward for private wealth disputes in Switzerland. They offer a robust, confidential, tailored alternative to litigation, and they address the multi-party and cross-border disputes and issues that often arise in these cases. However, we have to admit that some legal uncertainties still persist. quite a bit of it is also untested, and we hope that if arbitration is a bit more used in these areas, that there will be future case law that will clarify what you can actually do and what not. So we hope that there will be early adopters of the TEF rules that that will test the field and provide for case law, so that we get a bit more clarity on what you can do and what not. This concludes my presentation, and I hand back to Tatiana.
Thank you very much, Stephanie. I'm conscious of time, and we had a preliminary discussion between us, of course, which made us understand that the issue of private wealth disputes and their arbitrability is not so relevant for Ukraine at this stage. However, the arbitration of corporate disputes has been a topic discussed in Ukraine and even decided in some decisions by Ukrainian courts. And it would be really interesting to hear Sergei on the historic developments of arbitration of corporate disputes in Ukraine. And I think Alexei could add a few words about the current state of law and the recent case law of Ukrainian courts.
Yes, thank you, Tatiana. Indeed, the corporate disputes, arbitrability of corporate disputes, was a very debatable topic for quite a long time, and it is quite interesting that during most of the time when this issue was on the table, like was discussed, there was no express prohibition on arbitration of corporate disputes, but de facto those disputes were not arbitrable in Ukraine. And I think the history of corporate disputes and arbitration of corporate disputes in Ukraine starts with quite well-known case, Telenor versus Storm. This was a corporate dispute in relation to a very large, probably the largest Ukrainian mobile operator, Kyivstar, which began back in 2005 or maybe even earlier. And it involved the arbitration brought by Telenor in New York under the shareholders agreement with Storm, and it also involved a lot of opposition from Storm against this arbitration, including numerous proceedings in Ukraine to derail the arbitration, and they did so successfully, basically, in Ukraine. So what this case, this was basically the first instance when arbitration of corporate disputes came into spotlight in Ukraine. And I think this case also showed that Ukraine was quite hostile to arbitration of such disputes back then and for quite some time after that. In terms of regulation, in 2007, we got recommendations from the High Commercial Court of Ukraine. This is one of the highest Ukrainian judiciary. Those recommendations expressly prohibited arbitration of corporate disputes. And I think to some extent, this was these recommendations were influenced by the developments in Telenor versus Storm. But on the other hand, there was also some legitimate concerns in relation to arbitration of corporate disputes back then. And the concerns were that arbitration was sometimes used by fraudsters as a vehicle to take control of the businesses, to misappropriate funds, and so on and so forth. And obviously, we are not talking about some reputable arbitration institutions rendering such kind of awards, but there were instances, for example, when there was arbitration ad hoc seated, for example, in Moldova, issuing some very, very shady arbitral awards based on which then the corporate raids, the corporate attacks were conducted, and so on and so forth. And domestic arbitration courts were also abused quite a lot. And that was the reason, and I understand that it is quite wild for Swiss ears to hear that, but that was a really, really serious and concern in Ukraine, which impacted very significantly the discussions on these question further down the road, including, I think, by today. So in 2007 we had this recommendations from the High Commercial Court, and in 2009 when this rule prohibiting arbitrability of corporate disputes was added to the Commercial Procedure Code, so it became a part of the law. Quite interestingly, then in 2011, the Commercial Procedure Code was restated, and this express prohibition was removed. But the uncertainty as to arbitrability of the corporate disputes, it persisted. And quite importantly, the uncertainty extended further than just, strictly speaking, corporate disputes. So Ukrainian courts sometimes took a view that not only the disputes arising from the corporate governance are not arbitrable, but everything that is related to corporate relationship. Even, for example, the sale of shares in the company would also not be arbitrable, which is absurd, basically. But that was the decision, the decision that we had. I think a significant reform and more clarity appeared in Ukrainian law in 2017 with the comprehensive judicial reform and reform of procedural legislation and arbitration legislation. And I think I will now pass the floor to Alexei to talk about the current regulations.
Yeah, thank you very much, Sergey. And I'm currently sharing my screen. Can you see it? Is sharing okay?
Yes.
Yeah, so as Sergey stated, the issue of arbitrability of corporate disputes is closely linked to the Commercial Procedure Code of Ukraine, and indeed the history with respect to the treatment of the commercial disputes both by Ukrainian courts and the Ukrainian parliament is a roller coaster. And we arrived at certain equilibrium in 2017 during the procedural reform, when the issue was more or less settled in the Commercial Procedure Code. And there are several categories of dispute in the Commercial Procedure Code that can be viewed under the umbrella term of corporate disputes, and their arbitrability is regulated quite differently. So I will just go in turn addressing each one of them. So the first is derivative claims. So basically claims against the management of legal entities pertaining to the damages dealt to a legal entity. And it is quite clear from the Commercial Procedure Code that this category of disputes is not arbitrable. So they can only be addressed to the commercial courts of Ukraine, either when this is a claim addressed by the shareholders holding more than 5% of the company shares, which is the threshold for the right to file a derivative claim, or when they are addressed by the legal entity itself. As far as I understood, Tatiana, from your presentation, the situation is more or less the same in Switzerland with respect to claims against management for damages caused against the company, or can they be also submitted to arbitration?
They actually can for the shareholders, so they're not excluded. The derivative claims of creditors would be excluded.
Okay.
The shareholders' claims will be covered, and it's probably a very important area of corporate disputes, which can indeed be transferred from state courts to arbitral tribunals.
Okay, that's quite interesting because in Ukraine, a concept of a derivative claim by a creditor or third party, not a shareholder, is not a developed concept, and I'm not sure whether it at all would be possible under Ukrainian corporate law. So very interesting to compare the legislation here. So the second category and the broadest one is what we can call a proper corporate disputes, which cover the majority of things we would think about when speaking about corporate relations. So, for example, changes to the charter capital of the company, various resolutions of the managing bodies of the company, or payment of dividends, access to information, so on and so forth. All these issues are covered by Article 21(3) of the Commercial Procedure Code of Ukraine, and they are arbitrable, but subject to two important conditions. And these conditions are first that the disputes arise out of an agreement, and second that this agreement contains an arbitration clause to which both the legal entity and all the shareholders of legal entity are parties. So what do these conditions mean in practice? They basically mean that you cannot include an arbitration agreement into the Articles of Association of legal entity in Ukraine for two reasons. First, because although there are scientific debates about it, but Articles of Association or Charter are not viewed as an agreement under Ukrainian law, but rather as a sui generis legal act. So they do not meet the first precondition. And second, legal entity itself is not considered a party to its article of association or to its charter. So what this leaves us with, basically only the disputes arising out of shareholder agreements. But this is already, as we can deduce from the historic view presented by Serhiy, a development compared to the previous legislation regime with respect to arbitrability of corporate disputes. Because now, if you have a shareholder agreement to which all the shareholders and the company is party, you actually can include an arbitration agreement there and submit disputes to arbitration. To the best of my knowledge and from what I have seen from the analysis of the case law before Ukrainian courts, there have been no disputes or decisions of Ukrainian courts addressing the issue of arbitrability of this category of disputes. But at the same time, I have discussed this with colleagues from the transaction practice at Avellum, and they confirmed that when we, for instance, prepare shareholder agreements on the Ukrainian level for Ukrainian companies, we do often recommend to include arbitration agreements into them. So basically, this is an option that exists in practice. Unfortunately, unlike in Switzerland, as discussed by Tatiana, there is no requirement to publish the information about the existence of arbitration clause, and we cannot make any official inquiries with the corporate register, but the practice exists, at least from anecdotal evidence. And finally, the last category of disputes, which are also sometimes viewed as corporate, as discussed by Serhiy, but perhaps should not be viewed as such, are disputes arising out of transactions relating to share or other forms of corporate rights. Most direct examples are, of course, sale purchase agreements or pledge agreements. And there is a separate provision for such disputes in the Commercial Procedure Code and a direct statement that such disputes are arbitrable. There are no conditions, no strings attached. Nevertheless, in practice, litigants that find it inconvenient or not beneficial for them to abide by an arbitration agreement in, for example, a sale purchase agreement or share pledge agreement, often try to argue before Ukrainian courts that such disputes are in fact corporate disputes. This is especially the case where, for instance, a seller requests the return of shares sold under a sale purchase agreement, and the argument usually goes down two lines. First, that the disputes over the return of corporate rights are corporate because they are between a former member of the legal entity and the current member of the legal entity. So this is some sort of corporate relations between the members of the legal entity. And second, that the actual transfer of shares requires changes in the Ukrainian corporate register. This definitely concerns, for instance, limited liability companies. Therefore, since this is an issue related to the entries in state registries, it also should not be arbitrable under Ukrainian law. But fortunately, the practice of the Supreme Court after the procedural reform in 2017 was quite positive. So we have had a recent decision by the Supreme Court in the August of 2025 confirming that the disputes under sale purchase agreements are arbitrable and are not corporate disputes. And before that, in 2020, we had another case in which a party tried to argue that the dispute over the validity of a sale purchase agreement with respect to shares was corporate and was not arbitrable. And the first instance court in that case also dismissed this argument and concluded that the dispute was arbitrable. So to conclude, it is clear that compared to Switzerland, the scope of corporate disputes that can be submitted to arbitration is quite narrow, but we still see a positive development towards inclusion of more disputes into the category of disputes that can be submitted to arbitration. And although there are, of course, valid concerns regarding the past experience of misuse of arbitration, it is clear that there are areas for development and room to make more disputes arbitrable under Ukrainian law.
Thank you very much, Alexei, and we also hope very much that the presentation about the development on corporate law disputes under Swiss law and the broad definition of arbitrability in general in Swiss law could help the evolution of Ukrainian law and in particular court practice in Ukraine. I know we ran out of time, but I don't know if there are any questions from the audience which we should address at this stage.
I don't think we have any questions now, but we have had a question, I believe, received with the registration form. Stephanie, you were going to address that, if I'm not mistaken.
Yes, so that question related to the arbitrability of foundation disputes, and in particular, whether board members of foundations could actually be sued in arbitration, whether these matters would be arbitrable. Now, again, that really depends on the jurisdiction where you're in Switzerland, no problem, that would be arbitrable, even though, of course, we have a supervisory authority. In other countries, I understand that this may be well different.
Thank you very much, Stephanie. So I think it's the time to conclude this webinar and thank all the participants who joined us today. We all believe in the advantages of arbitration, in the confidentiality, in the efficiency, in the specialization of arbitrators. And we very much hope that the experience we share today from Swiss law could also benefit our Ukrainian colleagues. And for us as Swiss lawyers, it was very interesting to learn more about the very complex situation around arbitrability in general and about the evolution and history of arbitrability of corporate disputes in particular in Ukraine. I think this presentation was also beneficial to all Ukrainian lawyers as a reminder of the current state of law, and hopefully it's some food for thought as to the possible evolution in the future. So again, thank you very much for your participation. It was a real pleasure and a real honor to moderate this webinar.
Thank you. Thank you, Tatiana. Thank you, Felix, Stephanie, Sergey.
And thank you to ASA again for co-organizing this webinar.
Thank you. It was our pleasure. Thank you.
Have a nice evening. Bye.
Bye-bye.